Good morning, good afternoon, everyone, and welcome to Walmart versus Dukes 1 year later. My name is Angel Garganta. I'm a partner in the San Francisco office of Arnold and Porter, and with me are my colleagues Jamie Spire, a partner in the Los Angeles office, and our colleague Kelly Welchens, who is also in the Los Angeles office. Let me just make a few prefatory remarks. Please use the chat feature tool within WebEx to ask questions throughout the program. Due to time constraints, we might not be able to get through all of the questions, so please don't hesitate to contact one of us directly after the program. The lines have been muted. However, if you ever need assistance during the conference, press star then 0 on your telephone and a conference coordinator will be happy to assist you. This event is being recorded and may be posted on the Arnold and Porter website where it will be available to the public. For your convenience, shortly after the program, we will send a link with the presentation materials to all of the participants in today's program. So, with those remarks aside, let me just tell you a little bit about us. As I said, I'm a partner in the San Francisco office. I defend consumer false advertising class actions and have done so for most of my career. Jamie, who is a partner in the Los Angeles office, defends antitrust and consumer class actions. And Kelly has worked extensively with both of us on class action cases. As all of you probably know, the Supreme Court's decision in Walmart versus Dukes came down a year ago today, on June 20th, 2011. At the time, it was, and still is, widely heralded as the court's first significant class action decision since its 1997 ruling in Anchem Products versus Windsor. Depending on your perspective, the Walmart decision has either unfairly conflated the commonality inquiry under Rule 23A2 with the predominance inquiry under Rule 23B3 from the plaintiff's perspective, erecting an unjust barrier to plaintiffs seeking class relief. Or, if you're looking at it from the perspective of a lot of our defendant clients, it has appropriately clarified what the court's decision in Falcone meant by a rigorous analysis that the prerequisites of Rule 23A have been satisfied. We thought this 1-year anniversary would be the perfect occasion to reflect on the key holdings of Walmart, to dig into how they have been applied in the lower courts, and also to see if we can discern any resulting patterns in class action case statistics. So, today's topics. First, and as a starting point, we're going to revisit the key holdings of Walmart. We'll then take a look at some of the class action filings and class certification rulings in terms of the case statistics from two courts, the Southern District of New York and the Northern District of California, to see if Walmart has in fact yet had the quote-unquote radical impact that some predicted. Then we're going to look more deeply at the actual decisions. Jamie will lead us through a discussion of Walmart's enhanced commonality analysis as applied in the lower courts. Kelly will discuss the use of experts and Daubert analysis in connection with class certification motions. And I will round it out by discussing Walmart's impact on so-called trial by formula using examples from a few recent cases. Let's look at the key holdings. First, as I mentioned, the Walmart opinion reiterated what the Supreme Court had previously stated
for Asia Pac
in the Falcone case, that a trial court must undertake a rigorous analysis to determine if the requirements of Rule 23 are met. And it went on to say that will often require at least a preliminary inquiry into the merits of the case. In doing so, the court stressed that Rule 23 does not set forth the mere pleading standard. And what did it mean by that? Mere allegations aren't enough. It's no longer, even after Wal-Mart, enough that the plaintiffs have put forth some common evidence. If there's a battle of the experts raised in connection with a class certification motion under Wal-Mart, the court has to resolve that battle. This was already a trend in the courts before Wal-Mart, but it is now quite effectively the law in the federal courts. The court made it very clear that it was retiring the previously very often cited language in Eisen versus Carlisle to the effect that you didn't need to delve into the merits on class certification, as the purest dictum contradicted by its other cases. So it's no longer the case that a court can just rely on the pleadings to certify a class. Now, what was the holding on Daubert? There, the court noted that the district court had, in effect, erred in concluding that Daubert did not apply to expert testimony at the certification stage, saying we doubt it is so. And Kelly will go into some significant detail as to what the lower courts have done with that. With respect to trial by formula, and as I said, I'll get into more detail about that later on, the court referred to the Ninth Circuit's conclusion that it was possible to replace an inquiry into the individual relief in order, with respect to back pay or reinstatement. This was an employment case. It was a gender discrimination case, as you know, with so-called trial by formula. And trial by formula, in a nutshell, is essentially taking a percentage of the class, trying their cases, figuring out their damages, and then performing a statistical extrapolation to the class as a whole. The court specifically disapproved that method, referring to it as a novel project under which a class would be certified, but on the wrong premise, in effect on the premise that Wal-Mart or other defendants would not be entitled to litigate their statutory defenses to individual claims. So, in a nutshell, and what the court's basically saying here is that you not only need to look at the claims of the plaintiffs, but also you need to give the defendant a proper opportunity on class certification to raise its individualized defenses. So trial by formula would not work. And this would have been a violation, according to the court, of the Rules Enabling Act, which we quote here. With respect to Rule 23b2 classes, and this was also a significant holding of the case, the court imposed the stringent requirements of 23b3 when a class member would be entitled to an individualized award of monetary damages, and effectively said, and this is interesting because this was held by a unanimous court, not simply the majority that made the commonality in the other holdings, that when a class member would be entitled to individualized award of monetary damages, the class must satisfy the more stringent requirements of 23b3 and cannot be certified under the more permissive requirements of 23b2. So in other words, if damages are more than incidental, which was said in a number of places, and had been said in prior decisions in the lower courts, you cannot certify under 23b2. You have to look at the other requirements such as superiority and predominance that are stated in 23b3. So Jamie is now going to talk a little bit about the holding on commonality.
Hi, I'm Jamie Spire, and the court in Wal-Mart did something really remarkable when it reached the commonality portion of its decision. And what it did was it radically redefined the common question requirement of Rule 23A. And what was remarkable about this decision, one of the things that was remarkable, was that it really came completely out of left field. There was no circuit split on this issue that required resolution. Indeed, no lower court had ever construed the commonality requirement as the court did in the Wal-Mart case. And in fact, Wal-Mart's cert petition in this case didn't even raise the issue of whether the class had satisfied the Rule 23A commonality requirement. Instead, what the court did was it raised the issue itself, and then it asked the parties to brief the issue. So the court really went out of its way here to reach out and create new law sua sponte. And then if you get into the holdings on commonality, the way they started out was with this famous line about it's easy to misread. And what they said is the basic rule of Rule 23, that there has to be questions of law or fact common to the class, that's easy to misread. And what they're doing there is telegraphing that they're going to read this provision in a way that no one's ever read it before. That's what they're saying with easy to misread. And then they go on and they say that any competently crafted class complaint literally raises common questions, but reciting these questions is not going to be enough anymore to obtain class certification. So here, they have just jettisoned what everyone thought was all you had to do to satisfy commonality. Usually, all you had to do was, as practitioners are aware, is in the complaint recite a laundry list of allegations of issues that, according to the plaintiffs, are common to the class. And that was something that was rarely challenged by defendants, and that was the end of the story. That was the end of the commonality issue. What the court is saying here is that's not going to do it anymore. All right, then they went on to say that the claims have to be of such a nature that that the question will resolve an issue that is central to the validity of each one of the claims in one stroke. Okay, so there's two key words there. It's got to be central, and it's got to be one stroke. And so what they've done here is they've dramatically narrowed what qualifies as a common question. It's no longer just any common question. It's a common question that is critical to the case, and the issue must be capable of being resolved in one stroke. So they've radically and dramatically narrowed the types of common questions that people had previously thought qualified as common questions. Then they went on. Plaintiffs must show that class members have suffered the same injury. And they clarified, and this is this is part of the 5-4 decision that was authored by Justice Scalia. They clarified this and say, we don't mean merely that all class members have suffered a violation of the same law. We mean something more than that, more stringent than that. Okay, and then they went on and they said, this is what matters to class certification. It's not actually raising common questions, but it's rather whether a class-wide proceeding can generate common answers. And the interesting thing about what they've done here is they've shifted the focus from whether there's a common question to whether there's a common answer to that question. And this is going to require courts to examine whether there are dissimilarities among class members in how they were affected by the defendant's conduct and how they will prove their claims. And we'll get into it a little later, but there are some people, including Justice Ginsburg and 3 other justices, who think that this is really the province of the 23b3 predominance analysis, and this type of analysis has no place in the commonality analysis. Okay, then they said, in Walmart, you've got over 1 million class members seeking relief over their claims that they were discriminated against in terms of hiring and promotion. And what Justice Scalia said is, we've got claimants that want to sue about millions of employment decisions at once, and without some glue holding the alleged reasons for all those decisions together, you're not going to be able to get a common answer to the critical question, why was I disfavored in promotion or hiring? So this is a famous sentence. This is the famous glue sentence. And let me just go back to that. Here, the reformulation, the total reformulation of the common question 23A analysis is basically complete, because what they're saying here is not only do you have to have a crucial question here being why was I disfavored, but it's the answer to the crucial question that becomes the focus. It's the answer that has to be capable of common resolution. Okay, then the court's holding is because respondents provided no convincing proof of a discriminatory pay policy, they haven't established the existence of any common question. So this is significant because what they're saying here is that not only must the answer to the critical question be capable of common resolution, but plaintiffs at the class certification stage have to provide evidence proving that it's capable of common resolution. So in other words, there has to be a glue that binds all of the answers to the common questions together. And in the case of the Walmart situation, it would be a uniform policy of discrimination, which the court said didn't exist. So there not only has to be glue, there has to be proof of the glue. And that's a sharp contrast from before, where most lawyers and most judges thought that simply stating the common questions would suffice. And so with these passages, they really have radically transformed the commonality requirement. Then, very quickly, the dissent on commonality, which was authored by Justice Ginsburg and joined by 3 other justices, basically said, what are you doing? The commonality requirement, everyone thought, was something that you just kind of checked off and you never or rarely challenged. It was sort of like numerosity. It's something that had to be alleged and you moved on to the real fights, like whether there's predominance in a 23b3 class. And what Justice Ginsburg said is, you've taken this requirement that should be easily satisfied and you've transformed it into a very stringent requirement. And the dissent criticized the court, saying that basically what you're doing is impermissibly blending the analysis you have to do on 23B cases as to whether individual issues predominate over common issues, and you've moved it up in the analysis, and you've put it into the commonality analysis. Okay, so now we're going to hand it back to Angel for the next section.
Given Walmart's significant holdings that we've just gone through, and some would say it's a radical departure from past class action practice, and that's open to debate. I mean, some would say it was really a long-needed clarification. But given those holdings, many had predicted a dramatic impact on new class action filings, a reduction of class action filings, or at least a significant increase in the denial of motions for class certification. So we took a look at the figures, as I said, in two courts in the Southern District of New York and the Northern District of California, both of which have pretty heavy class action dockets. And we looked at them during the year since Wal-Mart was decided. In the Southern District of New York, and we also looked at them the 11 months before Wal-Mart. And the results, as you can see, were somewhat surprising. There were 512 class actions that filed in the Southern District of New York during the 11 months before Wal-Mart, and 593 filed in the 11 months after Wal-Mart. In the Northern District of California, 500 class actions filed in the 11 months before Wal-Mart, 480, a slight reduction, filed in the 11 months after Wal-Mart. Now, we're not statisticians, and I'm not particularly good with numbers. That's probably why I'm a lawyer. But, you know, it's not exactly a huge change. And if anything, you know, some filings went up, some went down, but seems to be pretty much the same. Impact on class certification rulings. Again, Southern District of New York, in the 11 months before Wal-Mart, 10 motions granted and 12 motions denied. In the 11 months after Wal-Mart, 25 motions granted and 10 motions denied. Would seem that, at least in that district, maybe Wal-Mart helped the plaintiffs, but I wouldn't jump to that conclusion. The Northern District of California, in the 11 months before Wal-Mart, 8 motions granted and 11 motions denied. And in the 11 months after, 9 motions granted and 10 motions denied. No significant change there. Anecdotally, and I guess, you know, by looking at the daily complaint services and so forth, I would say there has been somewhat of a trend towards increased filings in state court, perhaps on the part of some plaintiffs' counsel to try to avoid the effects of Wal-Mart. But that has to do with other factors as well, such as the Ninth Circuit's recent ruling in the Mazza case that I know Jamie's going to talk about in connection with commonality. So that's the statistics, at least from 2 districts. So we're now going to turn it back over to Jamie, and he's going to talk about commonality in some detail, as ruled on by the lower courts after Wal-Mart.
Okay, so we looked at what the lower courts have done with the new commonality requirement, and we wanted to see if this would be sort of a Bush v. Gore situation where this decision would essentially be ignored, or whether this was something that was really going to change the way lower courts performed the certification analysis. What we found, not surprisingly, is that there's very little at the circuit court level, basically, you know, due to the recency of the decision. But there definitely have been some interesting district court decisions, and so we thought it would be helpful to collect them and to talk about them a little. The first one is Haynes v. Planet Automall, which is a decision denying class certification on the basis of lack of commonality, and it's a Judge Weinstein decision, who it may not surprise listeners to know is still going strong at the age of 90. What Judge Weinstein said was that after Wal-Mart, common questions that are peripheral to the certification decision don't count in the analysis. Thus, the question that plaintiffs said was common, which was whether defendants' conduct violated New York's deceptive practices law, that's irrelevant to whether there's a common question under the new Walmart analysis. And he made clear, now to satisfy Rule 23A, the common question has to concern the critical disputed question. A district court case out of the Eastern District of Michigan involving title insurance also said that simply being able to articulate common questions no longer satisfies the common question requirement of 23A2. And echoing Judge Weinstein, it said there's going to be no commonality if the critical inquiry, without which liability cannot attach, requires individualized determination. So courts are focusing and taking to heart the language from Justice Scalia's opinion that the common question has to concern the critical issue in the case. Then you move on, a case out of the Southern District of Iowa. Once again, it recognizes that you have to look at what the crucial question is in order to satisfy the new requirement. And the crucial question has to be subject to common resolution. So let me just go back to Brown again. And so here what we have is a court accepting both major tenets of the Walmart decision and following those tenets, saying it's got to concern the crucial question in the case, and it's got to concern the answer to that question. The answer has to be capable of common resolution. It's no longer good enough just to focus on the question. And similarly, the court in a case from the Los Angeles District Court, Novak, says something along the same lines. There's no evidence that these common questions are capable of common resolution. A case from the San Diego Federal Court, I think it's Judge Battaglia, echoes this and says, okay, it's not going to be enough to do what plaintiffs thought was sufficient, which is just to have a laundry list of common questions, such as whether a defendant violated the same statute with a uniform corporate policy. And what the court found here in denying certification is that you've got dissimilarities in the proposed class, and that gets in the way of generating common answers. So these courts really are taking to heart the Walmart different approach. In Wang v. AT&T Mobility, the Central District of California again noted what everybody presumed, including Justice Ginsburg and her counterparts, which was up until the Supreme Court's recent decision in Walmart's, the commonality requirement was basically a pro forma requirement. But now, while you might have common issues, you're not going to get certification if there are not common answers to those common issues, and those common issues have to be issues relating to the key questions. And same thought here in the OnStar contract litigation out of the Eastern District of Michigan. You cannot any longer offer up the same kinds of broad questions that the court said would not do the trick in Walmart, such as, did all the class members' OnStar equipment cease to function? And taking Walmart very much to heart, they denied certification because there was no question for which the answer in the case would resolve an issue that's central to the validity of the claims in a single stroke. Okay, coming on to the commonality analysis and how circuit courts have looked at it. There's a case out of the Ninth Circuit, the Costco case, which was very similar to the Walmart case. It was a gender discrimination case. And what the court did was say, a la Walmart, if you don't have evidence of a uniform policy of discrimination, you are not going to have a question common to the class. And so what the court ended up doing was remanding to the district court to make that determination. And what this just shows is that regardless of the impact that Walmart may have in other areas of law, there's no question that it's going to have the most significant impact in the employment discrimination field. Also out of the Ninth Circuit is the recent Mazda v. American Honda case, which takes a sort of different approach to things. And Honda raised the Walmart-type arguments that there was no commonality here because you're going to, it's a determination of commonality is going to require the court to get into whether there are common answers that can be resolved in one stroke. And the court essentially rejected that argument and made the argument that Justice Ginsburg made in the dissent, which is, yes, Honda raises all these individualized issues, but that's an issue that really goes to preponderance under 23b3, and it's not really a commonality issue under 23a2. The court also noted that, by the way, plaintiffs listed a bunch of common questions, and Honda doesn't even challenge the district court's finding that those common questions exist and satisfy Rule 23a2. The court, let me just go back there for 1 second, but significantly, the court did say that plaintiffs had satisfied what it called their limited burden under Rule 23a2. And again, that sort of sounds much closer to the dissent's point of view than the majority's point of view in Walmart. And I think one way that at least the defense bar would criticize the American Honda case is to say that the court did not really take Walmart to heart because it did not focus on whether the answers to the crucial questions could be resolved on a common basis. It really focused more on whether the questions were common and really sort of ignored the new requirements imposed by Walmart. Okay, now I'm going to turn it over to Kelly Daubert to talk about...
Hold on before you go.
Let's talk about
questions?
that later, okay?
Okay.
Thanks.
Okay, my name is Kelly Welshins, and I'm going to talk about the impact on certification decisions for Daubert. As Angel talked about earlier, the Supreme Court said, the district court concluded that Daubert did not apply to expert testimony at the certification stage of class action proceedings. We doubt that is so. To us, this statement seemed to be a pretty clear expression of the Supreme Court's intent, but since Walmart, some circuit courts have agreed that a full Daubert analysis is required, and others have opted for what they call a more tailored or focused Daubert approach. We're going to start with the courts that talk about a full Daubert analysis being required. Messner versus North Shore University Health System is a Seventh Circuit case, and as you may know, prior to Walmart, the Seventh Circuit held an American Honda Motor Company versus Allen in 2010, that when an expert's report or testimony is critical to class certification, a district court must conclusively rule on any challenge to the expert's qualifications or submissions prior to ruling on a class certification motion. It's probably no surprise then that the Seventh Circuit followed its own precedent, but it also cited to the Supreme Court's decision in Walmart to bolster its conclusions. The plaintiffs had moved in this case to exclude the defendant's expert as unreliable, arguing that her economic analyses were fundamentally defective. The district court refused to perform a Daubert analysis of the defendant's expert and instead gave the expert's report what the court called the weight the court believed it was due. Not surprisingly, the Seventh Circuit cited to its opinion in American Honda, but also to the Supreme Court's opinion in Walmart, in stating, again, that when an expert's report or testimony is critical to class certification, a district court must make a conclusive ruling on any challenge to that expert's qualifications or submissions before it may rule on a motion for class certification. The Seventh Circuit then went on to describe why it thought a full Daubert analysis made sense at the certification stage, and directed the district courts that if it had any question or doubt about whether an expert's opinions were indeed critical to class certification, the court should make an explicit Daubert ruling. Part of the rationale for that is that if the court allows in unreliable expert testimony at the class certification stage, it opens itself up to reversal on appeal. Now, several courts have utilized what we've termed as Daubert light. In re Zernpeck's plumbing products liability litigation the decision was filed on July 6, 2011. This is just a couple of weeks after the Supreme Court's Wal-Mart decision. Nonetheless, the Eighth Circuit majority all but ignored Wal-Mart in evaluating the district court's analysis of the plaintiff's expert. The district court had performed a quote-unquote tailored Daubert analysis in which it evaluated the reliability of the expert testimony in light of the available evidence and the purpose for which the experts were offered. The Eighth Circuit approved this approach, again, more or less ignoring Wal-Mart, except to address the dissent's point about Wal-Mart in a footnote. The Eighth Circuit said that a full Daubert analysis was not the most workable option in complex litigation, especially due to the fact that discovery had been bifurcated in the Zernpeck's case. And because, as the Eighth Circuit said, class certification is inherently tentative. The Eighth Circuit rationale for this was that Daubert is intended to protect the juries from being swayed by dubious scientific testimony. In the Eighth Circuit's opinion, this isn't so much of a concern when the judge is the decision maker, such as at the class certification stage. The dissent called the majority on ignoring Wal-Mart. It noted that the Supreme Court had just recently disapproved of a failure to conduct a Daubert analysis. And the dissent noted that even if this was dictum, this dictum was very instructive on the Supreme Court's overall opinion on the issue. It also noted that class certification is no longer conditional as a result of the 2003 amendments to Rule 23. And as a result, the district court should delay certifying a class until it is satisfied that all Rule 23 requirements have been met, even if it needs to do additional targeted discovery to assess the reliability of an expert's opinions. In the dissent's mind, it's counterintuitive to utilize inadmissible evidence to resolve factual disputes at the class certification stage. And contrary to what the Eighth Circuit majority thought, the dissent believed that the purpose of Daubert was to evaluate the relevance and reliability of expert testimony, and this purpose is equally applicable at the class certification stage. A couple months later, Barron versus Comcast Corp was decided. The Third Circuit didn't go into a lot of detail about Wal-Mart in its majority opinion, although it addressed in a footnote the opinion, noting that the Supreme Court recently hinted that Daubert may apply for evaluating expert testimony at the class certification stage. The Third Circuit understood that the court's observation required a district court to evaluate if an expert is presenting a model which could evolve to become admissible evidence. And the Supreme Court's opinion didn't require a district court to determine if the model is perfect at the certification stage. In reading this case, we wondered whether Justice Scalia thought that his statement, "We doubt that is so," was merely a hint to the circuit courts, or what he would think really of the Third Circuit's understanding of the Supreme Court's opinion on this issue. Similar to Zernpeck's, the dissent called the majority on their analysis, and in its own lengthy footnote, Judge Jordan noted that both Circuit and Supreme Court precedent implied a Daubert requirement at class certification stage, and cited to the court's language in Wal-Mart doubting that Daubert doesn't apply at class certification. So then we get to the Ninth Circuit, where it appears that a full Daubert analysis is required, but there's some question in the lower courts. In Ellis versus Costco, which Jamie discussed a few minutes ago, the Ninth Circuit noted that Daubert requires the court to exclude junk science, and the court needed to admit or exclude expert evidence based on its scientific reliability or relevance. The Ellis court in the Ninth Circuit noted that the district court correctly applied the evidentiary standards set forth in Daubert. Now, we read this as a pretty clear indication that the Ninth Circuit is taking to heart what the Supreme Court said about doubting the prior analysis in Wal-Mart. And indeed, several district courts in the Ninth Circuit have cited to both Ellis and Wal-Mart in following this and performing a full Daubert analysis even at the class certification stage. One case that didn't do this was Bruce versus Harley-Davidson Motor Co. In this decision, the district court essentially ignored Walmart and decided to follow the approach laid out by the Eighth Circuit in In Re Zernpax. The district court performed a quote-unquote tailored Daubert analysis and said that the approach adopted by the Eighth Circuit was the appropriate application of Daubert at the class certification stage. Now, contrary to our reading of Ellis, the district court said that the Ninth Circuit had not, quote, definitively resolved the issue of whether Daubert was required at the class certification stage. And in supporting its own decision, the court noted the bifurcated discovery in the Harley-Davidson case and the preliminary nature of class certification proceedings. It also noted that a full Daubert analysis can be applied at a later stage of the case. So, where are we now? It appears to us that most courts are requiring that some sort of evaluation of expert testimony at class certification stage is required. But there is a current circuit split, and in the Eighth and Third Circuits, there appears to be some split among the judges themselves as to whether a full or a more tailored Daubert analysis is appropriate. This might be something that we require further guidance from the Supreme Court on, in addition to the hint that the Barron's Court believed that it gave.
Before we go on to the next area, which is trial by formula, we'd like to go back a minute to commonality because it's such an important part of the court's decision in Walmart. And I have a question for Jamie, I guess, and it's this. There's a lot of fuss about the enhanced commonality requirement and how commonality is supposed to be an easy hurdle, but does it make any difference really in a B3 class given the predominance requirement, and don't they end up sort of melding into each other anyway?
That's a very good question, Angel, and I'm glad you asked it. Yeah, I mean, certainly the cases that I went through, you can make a very strong argument that even without the enhanced commonality analysis, these courts would have ended up denying certification anyway once they got to the predominance analysis and decided that individual issues would predominate over common issues. But that doesn't mean that this decision doesn't really make any difference in the way certification decisions are ultimately going to come out. First of all, for 23B2 injunction classes, it's going to be tremendously important because there is no predominance requirement in 23B2 classes, and so the way they've narrowed the commonality analysis is going to make a difference in many, many B2 cases. But even for B3 classes, I think it still may be very important for a couple of reasons. Number one, it really opens up a whole new front in the battleground over class certification. Before, where the action had been focused on predominance, now you can fight on predominance and on common questions. And that may well turn out to be psychologically important when you are, as a defendant, trying to convince a judge to deny certification. Because arguing first that there's not even a common question can soften the judge up for when you get to the predominance analysis, because if by the time you get to the predominance analysis you've been convincing or trying to get to the point where a judge has doubts about whether a common question even exists, it may make it easier for the court to accept the fact that, considering everything as a whole, commonality and predominance, the plaintiff should not be entitled to certification. And then also, simply mathematically, what the court did in Walmart is to dramatically narrow the questions that will qualify as common questions. And then, because in the predominance analysis you have to balance the number of common questions against the number of individual issues and see which one predominates, simply mathematically and logically, if you reduce the number of common questions by following Wal-Mart, you should end up with more conclusions that individual issues predominate once you get to the B3 analysis.
That makes a lot of sense, although I still think there's an argument to be made that, you could apply something like the old commonality standard and very often end up not finding predominance. The Mazza case that you talked about earlier is a very good example of that, where the Ninth Circuit, as you said, took a different approach, but it ends up being a reversal of a class certification decision, finding individualized questions as to essentially the applicability of different state consumer protection laws. And in that vein, I was thinking about how Dukes is likely to impact cases beyond employment cases, and we've mentioned some here, and specifically focusing on our practice area, consumer product cases. It does strike me that judges now, and they've begun to do that in some decisions, are going to start looking a lot more carefully at cases where plaintiffs challenge claims about several aspects of a product. And I'm talking here about false advertising cases where they challenge several differently worded claims, where the advertising language or the prominence of claims varies over time, where the claims that are being challenged, the advertising claims, vary among products purchased by the class members, and finally, where the product characteristics themselves might vary over time and by product. In the past, we used to see, and we still see, a lot of products lumped together in one sort of blunderbuss complaint, but I think plaintiffs need to be a lot more careful about doing that since Wal-Mart, and we have seen several decisions denying class cert because of that variability on commonality grounds.
Absolutely, Angel. And in addition to the product misrepresentation area, you can conceive of how Wal-Mart could be used in the antitrust area. And for example, if you've got a price fixing case and you've got a class of indirect purchasers, what you could say is, well, here the crucial question is, was I overcharged? Just like the crucial question of Wal-Mart was I the subject of discrimination? Okay, so if the defendant can show variations in whether the direct purchaser passed on the overcharge to the indirect purchaser, the defendants would be able to argue that the answer to the crucial question, was I overcharged, simply cannot be resolved in the single stroke that Wal-Mart requires. Now, admittedly, if you're talking about a direct purchaser class, you're going to have more problems with that approach, and you may not be able to utilize Wal-Mart to that extent. But you may well have an argument in an indirect purchaser class in an antitrust action.
Okay, so let's talk a little bit now about trial by formula. As you'll recall, in Wal-Mart, the Supreme Court disapproved the Ninth Circuit's conclusion that damages could be determined on a class-wide basis by statistical sampling, or taking a percentage of cases, trying the defendant's defenses as to those cases, and then extrapolating as to the class as a whole. The lower courts, or at least in two cases that we have found, have applied that disapproval. In Cruz, which was an employment case, alleging that store managers were misclassified as exempt employees. The court found that the plaintiffs had failed to provide common proof of misclassification and decertified the class. Now, this was a class that the court had previously certified and had been through a few rounds of briefing. In particular, the court found that representative testimony about the nature of managers' job duties from a, quote, handful of class members was not enough, because the managers' views of the nature of their job duties varied highly. And in so holding, the court noted that Dukes had rejected a trial by formula approach akin to that which plaintiffs were proposing. The plaintiffs had proposed essentially a sampling methodology, taking a percentage of the cases, looking at forms filled out by the managers, and applying those class-wide. And again, it was based on the Supreme Court's rejection of trial by formula. The court in Cruz specifically referred to the Ninth Circuit case that really was the key case backing the trial by formula approach. It was Hilao versus the state of Marcos, which was decided back in 1996. And again, damages there were determined by selecting a small fraction of the class at random, referring them to a special master for valuation, and then extrapolating the validity and the value of the rest of the class member claims from that sample set. And the Ninth Circuit had concluded that a similar procedure was appropriate in Wal-Mart to determine whether lack of promotion or damages were based on gender discrimination. In Stone, which was mentioned earlier in the commonality discussion, the court was considering a case where it was alleged that it was unfair competition to provide loan documents. These were payday loans, loan documents in English, where the underlying negotiation of the transaction was conducted in Spanish. The plaintiff there had originally proposed to calculate damages using an expert's statistical evidence that Spanish was spoken in 23% of the transactions, and then applying that and making the extrapolation that 23% of the class was entitled to damages, again, referring to the Supreme Court's disapproval of the Hilao method as eliminating a trial by formula approach. The court ultimately denied certification of the class. So that wraps up our discussion of the case law in Wal-Mart, or based on Wal-Mart a year later. And I'd like to open it up for questions if anybody wants to ask any through the chat. We'd be happy to answer those.
Yeah, we had a question early on, which was how the case got up to the Supreme Court, and involving the point that the Supreme Court, involving the point that the parties didn't actually seek cert on the question of whether plaintiffs had satisfied the Rule 23A commonality requirement. And what happened was that the court never actually denied cert. The court granted cert, but then ordered the parties to brief the question of whether 23A had been satisfied in the case, even though the plaintiffs, Wal-Mart had never actually brought it up in the cert petition.
Any thoughts on Daubert, Kelly? Any additional thoughts?
Well, in reading some of these cases, we looked at whether the full Daubert analysis or some modified Daubert analysis is required. And when I talked about the Bruce versus Harley-Davidson case, the court did this modified analysis and then ended up excluding the expert. So while the modified Daubert analysis is not as strong as at least defendants would like, or it perhaps doesn't even follow the Supreme Court's suggestion, hint, whatever you want to call it, the fact that the district courts and the circuit courts are now at least applying some form of Daubert is a strong step forward, at least for defendants, that just the presence of expert testimony alone isn't going to be sufficient, that there's some analysis of that expert testimony is going to have to be done.
We have a question that asking for a sense of how California state courts are currently or will be viewing Walmart vis-a-vis wage and hour cases, seating cases, and or zip code cases. For those of you that aren't familiar with what seating cases are, there have been a number of cases brought alleging that not providing tellers, for example, with seats or other workers with seats violate the labor laws. And then the zip code cases involve, that's under the Williams-Sonoma case. The California Supreme Court decided that held that a zip code is private identifying information or personal identifying information. And there have been a number of unfair business practices cases brought against merchants asking for zip codes. It's really hard to say because the California state courts are the California state courts, and they don't follow Rule 23, and they're not obligated to follow U.S. Supreme Court precedent. They follow the precedent of the California Supreme Court and the California Code of Civil Procedure and Rules of Court with respect to class certification. I think that in some cases the state courts have invoked Walmart, but invoked it, I think, lightly in cases where they would be inclined to deny class certification anyway. One issue that has occurred to me, and I was discussing with Jamie earlier, with respect to the interplay between state law and federal law on specifically on trial by formula, is whether there might be an argument, and I say there might be, I haven't really thought through this, that the so-called fluid recovery method of determining class damages in UCL unfair competition cases in California or false advertising cases under Section 17200, 17500, whether that is a form of trial by formula, whether that argument could be made to a federal court looking at class certification, or whether instead it's not, but rather a substantive principle of law under the California statutes as interpreted by the Supreme Court of California, and Walmart has nothing to do with it. It's an interesting question with respect to the interplay of state and federal law here. I think that's it in terms of the questions, and we're going to wrap up a little bit early. We thank you all for participating, and we hope you found this one-year retrospective interesting. We enjoyed presenting it. Thank you very much. And I will round it out by discussing Walmart's impact on so-called trial by formula using examples from a few recent cases. Let's look at the key holdings. First, as I mentioned, the Walmart opinion reiterated what the Supreme Court had previously stated
3 for Asia Pac
in the Falcone case, that a trial court must undertake a rigorous analysis to determine if the requirements of Rule 23 are met. And it went on to say that will often require at least a preliminary inquiry into the merits of the case. In doing so, the court stressed that Rule 23 does not set forth the mere pleading standard. And what did it mean by that? Mere allegations aren't enough. It's no longer, even after Walmart, enough that the plaintiffs have put forth some common evidence. If there's a battle of the experts raised in connection with a class certification motion, let me just tell you a little bit about us. As I said, I'm a partner in the San Francisco office. I defend consumer false advertising class actions and have done so for most of my career. Jamie, who is a partner in the Los Angeles office, defends antitrust and consumer class actions. And Kelly has worked extensively with both of us on class action cases. As all of you probably know, the Supreme Court's decision in Wal-Mart versus Dukes came down a year ago today, on June 20th, 2011. At the time, it was, and still is, widely heralded as the court's first significant class action decision since its 1997 ruling in Anchem Products versus Windsor. Depending on your perspective, the Wal-Mart decision has either unfairly conflated the commonality inquiry under Rule 23A2 with the predominance inquiry under Rule 23B3 from the plaintiff's perspective, erecting an unjust barrier to plaintiffs seeking class relief. Or, if you're looking at it from the perspective of a lot of our defendant clients, it has appropriately clarified what the court's decision in Falcone meant by a rigorous analysis that the prerequisites of Rule 23A have been satisfied. We thought this one-year anniversary would be the perfect occasion to reflect on the key holdings of Wal-Mart, to dig into how they have been applied in the lower courts, and also to see if we can discern any resulting patterns in class action case statistics. So today's topics. First, and as a starting point, we're going to revisit the key holdings of Wal-Mart. We'll then take a look at some of the class action filings and class certification rulings in terms of the case statistics from two courts, the Southern District of New York and the Northern District of California, to see if Wal-Mart has in fact yet had the quote-unquote radical impact that some predicted. Then we're going to look more deeply at the actual decisions. Jamie will lead us through a discussion of Wal-Mart's enhanced commonality analysis as applied in the lower courts. Kelly will discuss the use of experts and Daubert analysis in connection with class certification motions. Good morning, good afternoon, everyone, and welcome to Wal-Mart versus Dukes 1 year later. My name is Angel Garganta. I'm a partner in the San Francisco office of Arnold & Porter. And with me are my colleagues Jamie Spire, a partner in the Los Angeles office, and our colleague Kelly Welchens, who is also in the Los Angeles office. Let me just make a few prefatory remarks. Please use the chat feature tool within WebEx to ask questions throughout the program. Due to time constraints, we might not be able to get through all of the questions, so please don't hesitate to contact one of us directly after the program. The lines have been muted. However, if you ever need assistance during the conference, press star then 0 on your telephone and a conference coordinator will be happy to assist you. This event is being recorded and may be posted on the Arnold & Porter website, where it will be available to the public. For your convenience, shortly after the program, we will send a link with the presentation materials to all of the participants in today's program. So, with those remarks aside, under Wal-Mart, the court has to resolve that battle. This was already a trend in the courts before Wal-Mart, but it is now quite effectively the law in the federal courts. The court made it very clear that it was retiring the previously very often cited language in Eisen versus Carlisle to the effect that you didn't need to delve into the merits on class certification, as the purest dictum contradicted by its other cases. So it's no longer the case that a court can just rely on the pleadings to certify a class. Now, what was the holding on Daubert? There, the court noted that the district court had, in effect, erred in concluding that Daubert did not apply to expert testimony at the certification stage, saying we doubt it is so. And Kelly will go into some significant detail as to what the lower courts have done with that.